The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. Thank you for joining us on this beautiful Monday, the last day of the month, as well as the last day of Fair Housing Month. We're so excited to be able to have Miss Marilyn Lefroy with us with the Louisiana Attorney General's Office. At this time, I'm going to give everybody a minute to kind of get situated on the webinar and make sure that your audio is coming in just fine. Everyone should be able to hear us at this point, though you don't have any microphone capabilities. We're going to handle questions through the questions box that's going to be on the right-hand side of your screen. But you should be able to see both the PowerPoint as well as hear us okay. If you can't hear us, go ahead and drop a message in the chat and let me know if there's some kind of audio issue. And we're just going to give everybody a few minutes to kind of get logged in and get situated. Everybody hear us okay? So far, no comments, so that's good.
That's good.
Thank you, Joe. Hope everybody's gotten a good cup of coffee. A lot of great information to be shared this morning. We're really excited to be able to hear from the experts who do this every day and hear what complaints they're receiving so that we can better help you understand and know what those things are in the field. Good. It looks like we're getting everybody in, so I'll go ahead and kind of get us kicked off. This morning we are joined by Ms. Marilyn Lefroy, who's the Compliance Officer with the Louisiana Attorney General's Office. Her primary job is to be able to review all the complaints and investigations that come through as it relates to housing opportunities, fair housing, and things that are happening in the field with consumers. She has been teaching and providing this information for us the last couple of years because there's a lot of things that from a realtor standpoint you need to be aware of and need to know. There's common scenarios that come up in day-to-day cases that end up being a fine line between what might be a violation and what doesn't. Her presentation today will go over some of the key definitions and things to look for, as well as things to be aware of as it relates to the protected classes, accommodations, and all of those things that can help you better be equipped in the field. So I'm going to kick it off and hand it over to Ms. Marilyn, and she'll walk through her presentation. We appreciate y'all joining us this morning.
Good morning. Thank you for joining in to your webinar. This presentation is basically to give you an overview of the compliance side of the Fair Housing Act and as it relates to you as a realtor. It's not moving. Bear with us here. Okay, this is a message from the Attorney General, Jeff Landry, and he says, as your Attorney General, he is committed to ensuring that the Louisiana Department of Justice serves all of our state's people. As your Attorney General, he said he would do all that he can to make Louisiana an even better place to live, work, and raise a family. This morning we're going to discuss the acts. What are the acts? We're going to talk about the Fair Housing Act on the federal side, the Louisiana Equal Housing Opportunity Act, which is our state statute, and we're going to go over some federal guidance that can assist you as a realtor. A fair housing complaint. How do you handle a fair housing complaint? What do you do when you receive a fair housing complaint? What are the enforcement and investigative process of the Louisiana Attorney General's office as a fair housing assistance program participant with HUD? What do we look for when we enforce the fair housing laws when it comes to a realtor? Any questions that you may have? And of course, we do have our contact information, which will be, I think it's the second to the last slide. So I have a lot of information for you. And if you have any questions, like Amy said, just write them out and then we'll answer them for you. Okay, so as you know, this year we're celebrating the 50th year of the Fair Housing Act. And of course, you know, the Fair Housing Act was originated in 1968, and this is the grand celebration of that milestone. Dr. Martin Luther King Jr. famously said, "Injustice anywhere is a threat to justice everywhere." And this is especially true with the rights to live where you choose. So let's look at a little bit of the history of the Fair Housing Act. Like I said, there are two components. There's the Federal Fair Housing Act, which can be located at 42 USC 3601. And of course, the Louisiana Equal Housing Opportunity Act can be located at Louisiana Revised Statute 512601, that's 2614. And the reason why I'm giving you this information, in the event you need to look up some case law or anything pertaining to a realtor, you would have where those statutes are located. You just Google Federal Fair Housing Act or HUD, and there's tons of information out there for you. So under the Federal Fair Housing Act, it stems from the Civil Rights Act of 1964, really prohibiting discrimination in federally funded programs on the basis of race, color, religion, and national origin. Now this was back in 1964. In 1968, the Federal Fair Housing Act was actually originated by Walter Mondale, and it was signed into law on April 11th of 1968 by President Lyndon B. Johnson, which was an amendment to the Civil Rights Act of 1866. And this is just a photo that I found in an archive of President Lyndon B. Johnson signing in the Civil Rights Act of 1968 on April 11th. It's a pretty old photo. In 1968, what Title VIII was meant as a follow-up to the Civil Rights Act of 1964. And what Title VIII did, it expanded on previous acts and prohibited discrimination concerning the sale, rental, and finance of housing based on race, color, religion, and national origin. In 1974, the Federal Fair Housing Act was actually amended to add another protective class, which is sex. In 1988, disability and familial status was added as protective classes. So today, there are 7 protective classes, which are race, color, religion, national origin, sex, and notice there's gender, which the LGBT community falls under that protective class, familial status, and disability. The primary purpose of the Fair Housing Act is to give all people the equal opportunity to use and enjoy their dwelling unit. The Fair Housing Act protects people from being treated differently in housing situations. So let's look at the Louisiana Equal Housing Opportunity Act. In 1991, the Louisiana Open Act was passed, and basically it was substantially equivalent to the Federal Fair Housing Act. And the only changes that has been made to the Louisiana Act is the title change, which was done on July 1 of 1999. They changed it from the Louisiana Open Act, the Senate did, to the Louisiana Equal Housing Opportunity Act. So who is protected? Everyone is protected under the Fair Housing Act. One word, everyone. Once again, the protective classes are race, color, religion, sex, gender, national origin, handicap, and familial status. So you have a right, everyone has a right to full enjoyment of housing, either offered to the public or has the right and ability to obtain housing. Any restrictions upon full enjoyment, it is a violation of the Fair Housing Act. Now there's some basic definition that I thought would be useful for you as a realtor. If you would get a complaint, who are the complainant? You could be a complainant. A complainant is any person who files an equal housing complaint. A respondent is a person or any other entity accused in a complaint alleging a discriminatory housing practice, or any other person or entity identified in the course of investigation and notified that they are respondents who shall be joined in the complaint. An aggrieved person is any person who claims to have been injured by discriminatory housing practice or believe that he or she will be injured by a discriminatory housing practice that is about to occur. Now, persons. A person under the Fair Housing Act is included in one or more individuals. It could be a corporation, a partnership, an association, labor organizations, legal representatives, mutual companies, joint stock companies, trustees, unincorporated organizations, trustees and bankruptcy receivers and fiduciaries. All these people a fair housing complaint can be filed against any person under this particular category. And as you know, rent is the lease, to sublease, to let, or otherwise to grant for consideration the right to occupy premises owned by an occupant. Now, under the Fair Housing Act, there are some exemptions. Any individuals owning no more than 3 properties is exempt from the Fair Housing Act. Any single-family house sold or rented by an owner, or religious organizations are exempt. Private clubs, not in fact that's open to the public, they're exempt, except if you would make, print, or publish a statement that's discriminatory. And then we'll get into that further in the presentation. So the types of housing of discrimination. What do we look for in the fair housing arena when we investigate fair housing complaints? What are the types of discrimination that we look for? We're looking for overt type discrimination, blatant unfair treatment of someone because of their membership in a protected class, just because they're a member of a protected class. We look for differential treatment, which could be an unsettled, unfair treatment of one person compared to another based on the membership in a protected class. Another type of discrimination we look for is disparate impact. And what that is a practice or policy which is applied uniformly, is applied to everyone, but will result in a discriminatory effect on a group of protected persons, and the policy is not justified by a business necessity. So let's look at race when it comes to the Federal Register. Under 24 CFR Volume 54, number 13 of 1989, when the Federal Fair Housing Act was actually written and the Federal Register was written, they identified these categories as race: Negro, Black, African American, Caucasian, Oriental, and American Indian. So let's look at a race example of possible housing discrimination. A white male applies to a bank for a home mortgage. He does not have a steady job or enough income to pay the mortgage payment. When he did work, the job did not pay very much. Because of his lack of a steady job and insufficient income, the loan officer decided not to give this person a loan. Do you think this is discrimination or not? Well, let's see. Answer: It is legal for a loan officer to turn down an applicant because he or she lacks sufficient income to cover a monthly mortgage payment. The scenario clearly states that the bank denied the mortgage because of insufficient income and not because of race or other protective characteristics. So that's not discrimination. Under Federal Register, color is defined as white, black, or colored. Okay, go figure. All right, so let's look at a color example. The next question involves a family selling their house to a real estate agent. They are white and have only white neighbors. Some of the neighbors tell the family that if a non-white person buys the house, that would be trouble for that buyer. Not wanting to make it difficult for the buyer, the family tells the real estate agent they will sell their house only to a white buyer. Is that discrimination? Yes, I know you would agree. It is illegal for a family selling their house through a real estate agent or broker to restrict the sale of their house only to white buyers. The law exempts from this prohibition single-family housing sold without the service of a real estate agent. However, because the family portrayed in the scenario is working with a real estate agent, the family cannot restrict the sale of their house because of race or other attributes, affiliation, or conditions as stipulated in the Fair Housing Act. Religion under the under the Federal Register is defined as Protestant, Christians, Catholic, Jews, and Muslims. So let's look at a religion example. A condominium association learns that an applicant for the purchase of a condominium has a different religious belief than all the other condominium owners who are members of the association. Because the other association members would object, the condominium association does not want to sell to such a person. Is that discrimination? Yeah, I would think so. It is not legal for a condominium association to reject or otherwise discriminate against an applicant based on religion, even if an applicant believes other members would object or that it would somehow better for current or prospective owners. If the latter was rejected because of religion, it is against federal and state law to do so. So another protective class under the Fair Housing Act, and I know I'm moving pretty fast through these slides, but I really want to get to the heart of what we need to present to you on this morning. Sex discrimination. Under sex discrimination, there's gender discrimination, male or female, discriminate against someone because they're male, discriminate against someone because they're female, sexual harassment, quid pro quo. I'll let you out of your lease if you perform sexual favors, or I wouldn't collect your rent, sexual harassment, inappropriate comments and touching, creating a hostile environment. Under HUD's new rule, the lesbian, gay, bisexual, or transgender population, the LBG, that population falls under sex discrimination, and it's called the Equal Access Rule. You can locate that particular rule and guidance if you want more information about it from HUD's website, or you can go to 24 CFR Section 5.105A2. So let's look at a sex example. You are a leasing agent for your broker. You hear a landlord tells a female tenant that she did not have to pay her rent for the next 3 months if she would agree to a special relationship with him. The landlord continued to request special favors from the female tenant. The female tenant rejected the landlord's request at all times. After the female tenant continued to reject the landlord's request for the final time, the next day the landlord issued the female tenant an eviction notice. So what do you think about that? What would you do as a leasing agent? Okay, the answer is this is discrimination. Quid pro quo. They were harassing her. Sexual favors, which is a violation of the Fair Housing Act. And then as a leasing agent, you can file a fair housing complaint on behalf of the aggrieved person or be a witness to the alleged fair housing violation. National origin, let's just look. This is a list of the national origin that's listed under the Federal Register as far as HUD's the Federal Fair Housing Act is concerned. This is just a list. I'm not going to go through each category, but just for your information, this is what HUD looks at. So let's look at a national origin example. As a real estate agent, you are assisting an Hispanic family with the purchase of their first home. The Hispanic buyer goes to a bank to apply for a home mortgage. The buyer qualifies for the mortgage, but in that bank experience, Hispanic borrowers have been less likely than others to repay their loan. For that reason, the loan officer requires that the buyer make a higher down payment than would be required of other borrowers agreeing to give the mortgage. Is that discrimination? Yes. It is illegal to require a higher down payment from this otherwise qualified applicant than would be required on similar qualified persons. While the loan officer appeared to be making a business decision, federal law prohibits a lender from profiling an applicant based on race or color, national origin, religion, sex, familial status, or disability, and as a result, imposing differential terms and giving different treatment. So as a real estate agent, the loan has been denied, which caused an impact on you from receiving your commission from the sale of the property. Therefore, you have been harmed by the discriminatory lending practice of the lender. So who can file a complaint? The Hispanic buyer in refusal to make a loan, because basically it was being stereotyped. And the real estate agent, you, as an aggrieved party because of association with a member of a protected class. And then at that point, you could request your commission that you would have actually earned in that sale. So let's look at handicap, which is another protective class. Handicap is defined as a physical or mental impairment which substantially limits one or more major life activities. It could be a record of such an impairment or being regarded as having an impairment. The term does not include controlled substance. So some of the persons with disabilities, major life activities may be seeing, hearing, walking, breathing, performing manual tasks, learning, speaking, can't take care of oneself. That is what is considered a major life activity with in the guidance. So under handicap, there are 3 categories. There is what we call a reasonable accommodation, and what a reasonable accommodation is no more than a rule change to a policy. You may have a reasonable modification, which is a physical change to a structure, or maybe requesting a ramp where for access to a unit. And of course, design and requirements, construction requirements, that's all part of the Fair Housing Act. So under a reasonable accommodation, once again, it is a rule change. It could be a policy or practice, and designating a handicap parking space when there's a no handicap parking area. That could be a reasonable accommodation. Access for a personal care attendant. Allowing a CNI dog and a motion support animal where there's a no pet policy. Accepting a late pay for a Social Security disability check when the rent is due on the 1st and they don't get their check until the 1st, or another date by Social Security. Well, then at some point, you can make a reasonable accommodation just to accommodate that person based on their disability. This is a category I wanted to present to you guys this year because I think the last time I conducted a presentation for you, the insurance policy restriction question came up, where I did locate an memo that came from HUD regarding what happens when a reasonable accommodation request is made and denied based on the breed of a dog when the insurance carrier considers the breed dangerous. And some examples of a coverage refusal is the insurance carrier refuses to cover the property, The insurance carrier substantially increases the cost of the coverage of the property. The insurance carrier changes the terms of the housing provider's policy if a certain breed of an animal is allowed to occupy a dwelling. The clearest thing I can tell you is to refer to HUD's joint statement that's dated May 17, 2004, regarding reasonable accommodations under the Fair Housing Act. And I'm going to go a little bit more in depth to it, but the answer lies here, okay? So when can a provider deny a request? This is the information that HUD basically answered that question through the joint statement, and basically says, when a request was not made by and on behalf of a person with a disability, the individual does not have a disability, or no disability-related need for an accommodation is needed, or if providing accommodation is not reasonable, okay? If it would pose an undue financial and administrative burden on the housing provider, or it would fundamentally alter the nature of the provider's operation. So under the insurance provision, if evidence finds that an insurance provider has a policy of refusing to insure any housing that has animals, without exception of assistant animals, the housing provider may refer that information to the U.S. Department of Justice or the U.S. Department of Housing and Urban Development for investigation. Those complaints would not more or less come through our office, the Attorney General's office. They will be handled on the federal level. So we can get a complaint, but we'll refer you to HUD or the U.S. Department of Justice.
I think we have a question. Wanda, it looks like you have your hand up. Do you want to use the question box to ask your question if you still have your question? I know a lot of times, Ms. Marilyn, in our office, we get a lot of questions about reasonable accommodation. What are they required to do? How does it apply to, pets? If the landlord has a no pet policy, what are the things that they need to ask for in order to see whether it's a legitimate accommodation? Like, what do y'all get in terms of complaints or issues, or how can you determine or tell when a reasonable accommodation is necessary?
Okay. Now, initially, when someone requested a reasonable accommodation, what do you have to, there has to be a need for, let's just say if they have an assistant animal. There's a difference between an assistant animal and a service animal. An assistant animal is more or less we call, or we may say, a emotional support animal, okay? They don't require training. They don't require a certificate. But what you need to know as a leasing agent or someone, if there's a no pet policy, that there's a need for that animal. There's a connection between their handicap and the need for that assistant animal. What you would get would be a doctor's prescription saying that there's a need for this service animal, or you may get a psychiatrist statement just saying that yes, there is a need because this animal is used for a medical necessity. It's not used for just to be having an animal, in the unit. But with a service animal, if that service animal, mostly ADA says that it is a dog, and basically it's allowed, you have to allow that reasonable accommodation for that particular service animal. Okay, but the first thing you would want to do is make sure that there is a connection. There is a need for the animal. Okay, you cannot charge them a pet policy fee. If there's a fee, you'd have to waive that. But make sure that there is a need. That's the answer, the key. There has to be a need for the animal, and they have to provide you with something to say that that animal is for a medical need, because we have some people just want their little dog, but if there's a no pet policy and it's not a medical necessity, well then that's not a violation of the Fair Housing Act if they've been refused. Okay. I hope I answered your question. Okay, so let's go into reasonable modification. Reasonable modification is a structural change. If a property was built before March 13, 1991, the tenant pays for the modification if it was built before 1991. If the property was built after 1991, but then it is the owner's responsibility because it should be already ADA in compliance.
Ms. Marilyn, I have a question. The comment that you made regarding the certificate of a service dog. So the question was, if there is a certificate showing that it's a service dog, then you can't charge a pet fee?
Do not charge a pet fee, no, no. That's a violation. And they can file a fair housing complaint requesting a refund of that fee.
Okay.
Yeah, yeah. No, you have to waive the fee.
Okay.
Because it's not a pet. It's a medical necessity animal.
I see.
Yeah. And that's the difference. Yeah, it is a difference.
Okay, Lauren, does that answer your question? What if there is an emotional support plus a service dog?
You have to allow them. You have to allow them. A service animal is a service animal. An emotional support assistant animal is an assistant animal. For some reason, the doctor or psychiatrist or whoever prescribed those animals said that that individual need those animals for them to make them whole. So you cannot deny that request. Now, what can be a nuisance? And we've had this to come through the HUD. Somebody wanted a little baby elephant, you know.
A baby elephant?
A baby elephant. And according to our regional director, HUD had to allow it. As long as it wasn't destroying the property, tearing up the property, disturbing neighbors, anything like that, it was quiet. I mean, they had to allow it because it was therapy for that individual. I mean, as far out as it may seem, it happens, you know.
That is very far out.
You know.
So when you have that kind of scenario and somebody wants both an emotional support animal or a service animal, then they should have some sort of documentation
They have to have
that's
a
provided.
Right.
Is it by is it by their psychiatrist? Is there
It's a doctor, and
document?
you have to have a doctor's statement, or it could be a psychiatrist, a social worker, anyone that says that's prescribing that they need that animal. And once again, it's not a pet. It's for a medical necessity.
So what happens, have y'all heard of the issue with people receiving these certificates through a service online? How does an agent go about verifying something like that for their clients or for their their tenant, the client that they're working for?
Well, we've had this come up in our office regarding these supposedly fake certificates.
Yes.
But once again, if you look at HUD's website, and this is why I want to refer you to HUD's website, the requirements, look at the joint statement when it comes to reasonable accommodations. And it actually lays out what the requirements are. Go to that joint statement and it actually tells you how to request the information, because it's a lot of information and I really don't have a whole lot of time now to discuss it. But there's a whole bunch of websites out there. People pay $99, they get a certificate, they answer a few little questions, they get a certificate, and they say, yes, I have this service animal, and they're certified now, okay? But the premise of you can get that offline, but do you have a doctor's statement saying that that animal is necessary? Do you have a statement from a psychiatrist or whoever's treating you saying you need that animal? You know?
See.
Because anyone can go on the website and get that.
So there should be some sort of medical backup.
You need a medical
well.
backup. That's just to say that you got a certificate, but where's your medical proof?
Got it.
Yeah.
So what are the steps that maybe a real estate agent can take in order to verify that?
I wouldn't try and verify. What I would do is have the tenant to bring me the information.
Okay.
If I'm the leasing agent or helping, property management company,
Right.
I'll have them to bring me the necessary documents.
Okay.
Those documents are a statement from your doctor, medical professional, stating the need for the animal. That's your connection. Okay. Once you get that, okay, as far as a service animal, they're going to have a certificate anyway, saying that they're trained. For an assistant animal or an emotional support animal, use those terms interchangeable. You don't need a certificate. All you need to have a doctor's statement or a professional statement saying that there is a need for the animal. That puts it under the medical umbrella. Okay.
Okay.
And then that's when everything is just waived.
So you should be able to keep that documentation with all of your paperwork.
With your paperwork,
Yeah.
right? With your paperwork, yeah.
Great.
Okay.
If there's any other questions on that subject, please send them in. I think it helps to get kind of what's happening in the field and hear from what they're looking for and what kind of things come into their office. I'm still in shock about somebody wanting a baby elephant.
Oh, yeah, yeah. Well, we're dealing with some very strange animals now. Okay, and of course, back to the reasonable modification, a tenant space for the modification beyond the 7 design requirements. And I'll briefly go over those with you. And if the tenant vacates the property, they must return the property to its original state. So let's look at the 7 design requirements. What are they? An accessible building entrance on an accessible route, an accessible and usable public and common use facility, usable doors for a person in wheelchairs, accessible route into and through the covered unit, light switches, electrical outlets, thermostats, and other environmental controls in accessible locations, reinforced walls for grab bars, usable kitchen and doors and bathrooms, sorry. So let's look at a handicap example. As a real estate leasing agent, a landlord is checking references on an application for a vacant apartment. An apartment building owner learns that the applicant has history of mental illness. Although the applicant is not a danger to anyone, the owner does not want to rent to such a person. Is that discrimination? Yes. It is not illegal for an owner to reject an applicant because of mental illness. However, housing does not have to be made available to a person who is a direct threat to the health and safety of others or who is currently using an illegal drug. The scenario clearly specifies that the person is not a danger to anyone. As a real estate agent, you should report the incident. So HUD came out with a notice 12-1301, and the purpose for that was to explain certain obligations under the Fair Housing Act when it comes to the Fair Housing Act, Section 504, the Rehabilitation Act, and Americans Disabilities Act, the ADA. And this is where we're going to get into the service animals, okay? There's 2 types, service animals and assistant animals, which are forestated. And a service animal, as defined under U.S. Department of Justice, uses the American Disabilities Act definition as of March 15, 2011, and basically says that any dog, now a dog under the service animal category, is what the USDA, U.S. Department of Justice, identify as a service animal. Any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or other mental disability. An ADA covered facility may ask 2 questions. Is this a service animal that is required because of a disability? That's the only thing you need to know. Is there a disability? And that's why I said when you need a nexus, you need to know that there is a connection between the service animal that they're seeking to place in the unit and a disability. And what work or task has the animal been trained to perform? Okay, a service animal may not be denied access to an ADA covered facility unless the animal is out of control and its handler does not take effective action to control it, or the animal is not housebroken, and that is trained so that the absence of illness or accident, the animal cannot control its waste or limitation. So if it's destroying the property and not being maintained, you can deny the access. Or the animal poses a direct threat to the health and safety of others that cannot be eliminated or reduced to any acceptable level by a reasonable modification to other policies, practices, or procedures. So let's look at a service animal example. A handicapped epileptic person lives in an apartment complex and requested a reasonable accommodation to a no pet policy to have her trained animal, half pit bull and half Labrador, be allowed in her unit. She submitted the necessary paperwork with a signed doctor's prescription and the training certificate of her service animal. Because of the breed of the service animal, the landlord rejected her request because pit bulls are considered a vicious breed. Is this discrimination? Yes. The landlord cannot discriminate against breeds, period. Unless the animal is a threat to others, the owner cannot control the animal or the animal has caused destruction to the property, the request must be granted. So let's take a look at assistant animals. What is an assistant animal? An assistant animal is not a pet. It is an animal that works, it provides assistance, it performs tasks for the benefit of persons with a disability. It provides emotional support. It guides individuals who are blind or have low visions. It alerts individuals who are deaf or hard of hearing sound. It provides protection or rescue assistance. It pulls a wheelchair, fetches items. It alerts persons with impending seizures. It provides emotional support to persons with disabilities who have a disability-related need for such support. So you can deny a request when, once again, when the specific animal imposes a direct threat to the health and safety of others that cannot be reduced or eliminated by another reasonable accommodation, or the specific animal in question causes substantial physical damage to the property of others that cannot be reduced or eliminated by another reasonable accommodation. So that goes both for the service animals as well as the assistant animal. So let's look at an example of an assistant animal. A housing provider has a no pet policy, and a tenant who is deaf requests that the provider allows him to keep a dog in his unit as a reasonable accommodation. The tenant explains that the dog is an assistant animal that will alert him to several sounds, including knocks at the door, sounding of the smoke detector, the telephone ringing, and cars coming into the driveway. Can this request be granted to the no pet policy? Yes. The housing provider must make an exception to his no pet policy to accommodate this tenant. For the purpose of a reasonable accommodation request, neither the Fair Housing Act nor Section 504 require an assistant animal to be individually trained or certified. Breed, size, and weight limitations may not be applied to an assistant animal. So let's look at another protective class, which is familiar status. And what familiar status is individuals who, one or more individuals who have not maintained or attained the age of 18, who actually domicile with a person, with a parent, another person having legal custody of such an individual, or a designee of such a parent or other person who have custody of a child or written permission by a court. So let's look at a familiar status example. As a real estate leasing agent, an apartment complex builder owner who rents to people of all age groups decides that families with younger children can only rent in one particular building and not in others because younger children tend to make a lot of noise and may bother others. Is this discrimination? This is not lawful. Notwithstanding the rationale presented for differential treatment of families with children, the children make noise and may bother the tenants. Federal law does not permit such actions in most apartment settings. The owner in this scenario rents to people of all age groups, and therefore the apartment complex is not restricted to senior-only living. Based on current federal law, landlords may not, under these circumstances, treat families with children under the age of 18 different from others, either with respect to building assignment or any other way. So let's look at what constitutes housing discrimination. Refusal to rent or sell because of any one of the 7 protective classes. Make, print, or publish a statement or notice that has a limitation or preference or any type of discriminatory statement constitute housing discrimination. Setting different terms and conditions because of someone's or an individual's protective classes. Falsely denying that housing is available for inspection or for sale or rent because of protective class. So let's look at some warning signs of housing discrimination. Refusing to rent or sell because of protective class, advertising or posting a notice about the sale of a rental of a dwelling that indicates a preference, limitation, or discrimination, different terms and conditions or privilege for certain people, falsely denying that housing is available for inspection, sale, or rent, intimidating, interfering with, or coercing a person to prevent them from buying or leasing a dwelling. Steering by a real estate agent to and from a certain neighborhood, or steering by a landlord to or from a certain area of a complex, neighborhood, or a trailer park. Some other components of warning signs are discriminating against someone through financing or broker services, engaging in blockbusting practices in connection with the sale of a rental of a dwelling, using different provisions in leases or contracts or sales such as rental rates or down payments, failing or delaying maintenance or repairs or a sale of a rental dwelling, failing to process an offer of the sale or rental of the dwelling or to communicate an offer adequately, limiting the use of privileged services or facilities associated with the dwelling, such as access to a laundry facility, denying or limiting service of facilities in connection with the sale of a rental of the dwelling because of a person failed or refused to provide sexual favors. So let's look at a real estate transaction, and this is where you as a real estate agent falls under your practices, falls under with the Louisiana Revised Statute 512607. And basically it says that it's unlawful for any person or other entities whose business included engaging in a real estate related transaction to discriminate against any person in making available such a transaction or in terms or conditions of such a transaction because of race, color, religion, sex, handicap, familial status, or national origin. And a real estate transaction includes financing, and that is the purchasing, the constructing, improving, repairing, or maintaining of the dwelling. Anything that's secured by real estate, residential real estate, is protected under 512607, and that includes selling, brokering, appraising of a real estate property. So let's look at another category under real estate, which is steering. And you can find that information of steering under 512606 under Louisiana Revised Statute Part 4. And of course, steering does not mean driving a car. Let me see if I can get my little vehicle up there. There you go. Steering means driving you to another location. And that is discouraging a person from the purchase, lease, of an inspection of a community, neighborhood, or development floor of a section. Just taking them, driving them to where you feel they should go instead of what they have, how they qualify.
How would you advise real estate agents to be able to inform their clients without walking that fine line between what's considered steering? If they're working with buyers and buyers ask questions regarding certain
What I would
areas.
just tell them is what's available on your MLS listing. These are the properties that I have available based on what you're willing to pay. These is the areas that they're located in. I wouldn't go in neighborhood locations. I wouldn't even discuss it. This is what we have listed, and if you qualify for $120,000, this is the houses that we have available in the $20,000 range. I'll be happy to show you. This house is at 119. This one might be 110. I'll be happy to show you that. Do not encourage them to go into other areas. Just say, this is what we have available, and that's it. Don't even address, oh, you may like this or you may like that in this area. No, this is what we have available on our MLS listing in your price range. And that's all you look for. I mean, if they say, well, do you have something in another area? If they say it, but don't you encourage as a real estate agent to say you may like this area. Don't do that. No. Okay. All right. So steering is unlawful to represent to any person because of race, color, religion, sex, handicap, familial status, or national origin that a dwelling is not available for inspection, sale, or rental when such a dwelling is in fact so available. So let's look at some of the warning signs of steering. That is discouraging a person from inspecting a dwelling in a particular community, telling a prospective purchaser or renter he or she will not be comfortable or compatible with an existing residence or community, neighborhood, or development, assigning a person to a particular floor, a section of a building, community of development. So let's look at an example of steering discrimination. A white family looking to buy a house goes to a real estate agent and asks about the availability of houses within their price range. Assuming that the family would only want to buy in a predominantly white neighborhood, the agent decides to show them only houses in all white neighborhoods, even though there are many other houses in their price range in other parts of the community. Is that discrimination? Yes, it is illegal for a real estate agent to restrict a client's housing search to neighborhoods of a certain racial components. This type of behavior, typically called steering, involves systematically showing minority home buyers houses in neighborhoods different from those shown or recommended to compatible white homeowners. Systematically steering minorities away from predominantly white neighborhoods and vice versa is a form of discrimination that limits housing and neighborhood choice and may play a role in perpetuating patterns of residential discrimination. The fact that in this scenario the family is white and that the house shown in a white neighborhood only, based on the decision of a real estate agent, does not change the fact of such practice nor make them less a violation of the Fair Housing Act. So let's look at blockbusting. It shall be unlawful for profit, and that's the key with blockbusting. It has to be for profit to induce or attempt to induce a person to sell or rent a dwelling by representation regarding the entry or prospective entry into a neighborhood of a person or persons of a particular race, color, religion, sex, familial status, national origin, or with a handicap. Blockbusting prohibited transactions that's unsolicited, uninvited soliciting from a listing agent, conveying to a person that a neighborhood is undergoing or about to undergo a change in the race, color, in order to encourage the person to offer a dwelling for sale or rental, or encouraging for profit through searching by lowering the property value and increasing criminal anti-social behavior or other services to facilities. In blockbusting, in establishing a discriminatory housing practice under this section, it is not necessary that there was in fact for profit, as long as the profit was a factor engaging in the blockbusting activity. So let's look at broker services, and that is setting different fees for access to or membership into multi-listing services, denying or limiting benefits occurring to members in a real estate broker organization, imposing different standards or criteria for membership in a real estate sale or a rental organization, establishing geographic boundaries, office locations, residential requirement for access to or membership or participation in a multi-listing services or real estate broker organization or facility relating to a business of selling or renting a dwelling. Okay, so let's look at terms and conditions. And that is, what is terms and conditions? That is treating someone differently because of one of several of the protected class. And that is using different provisions in a lease or contracts of sale of a rental, lease agreement, security deposit, down payment, closing costs, of failing or delaying maintenance or repairs of a sale of a rental unit, failing to process an offer of a sale of a rental of a dwelling, or to communicate an offer adequately because of a protective class, limiting the use of privileges, services, and facilities associating with a dwelling, and that is limiting the use of the laundry room, exercise room, the most common areas at a complex, denying or limiting services or facilities in connection with the sale of a rental of a dwelling, because of failing or refuse to provide sexual favors. So now let's go into advertising under the Fair Housing Act. When does discriminatory advertising occur? When an advertiser makes, print, or publishes, causes to be made, or expresses an intention to make in a notice, statement, or advertisement, and that includes the internet advertising as well. You cannot make, print, or publish a statement that's discriminatory. It cannot indicate a preference or limitations with respect to the sale or the rent of a property against any of the protective classes. So some of the things that we look for when we investigate fair housing complaints when it comes to discriminatory advertising is words, the phrases, photos that may be discriminatory, symbols or illustrations, or any other type of forms that may relate to be discriminatory. Discriminatory advertising may convey availability or non-availability against a protective classes, expressing to an agent, an employee, or renter a preference or a limitation, refusing to publish advertisement due to a protective class. So it is illegal to advertise or to make any statement that indicates a limitation, preference based on the 7 protective class, and it all applies to housing, even if the property is exempt. You remember when we first started and we looked at the exemptions, and I said there's some exemptions under the Fair Housing Act. If an individual has 3 or less properties, they're exempt. But if they make, print, or publish statements that's discriminatory, but then they're not exempt, that trumps them out.
Miss Marilyn, so does this advertising apply to print? How has the regulations changed or adjusted as a result of like kind of the online, posting?
Okay.
Or how does that work?
Okay. There is like comments, like let's say for rental, no children. I mean, that's the basic one we see a lot. No children or no service animals. Even though they have a no pet policy, they specifically say no service animal. Now, the way it works and the way HUD explained it to us, let's just say you have like Craigslist out there, who is a service, who is a engine. It's just a search engine. You have Google out there. You have all these other search engines where you can post information out there.
Right.
They're not the one that's discriminating. They're just allowing you out there like a billboard to allow you to put your flyer up there.
Sure.
It's the individuals who's actually posting the discriminatory statements. Those are the ones that we go after.
So how does that work? Does there have to be some sort of proof or capturing
it's a capturing.
The post?
What it is 9 out of 10. You'll be surprised that the people just go out to websites and they look for discriminatory statements and they file a complaint. There's testers that does the same thing. They just go out to, let's say Craigslist, because that's the one and only.
Right.
And we just go out and they just look for discriminatory advertisement. Or they may go to Louisiana Realtor's website and see if you guys may have something out there that's discriminatory, that indicates a preference or may indicate a limitation, or it just may have a discriminatory statement on it, you know. So that being said, what happens is those complaints have come to our office through a form of a fair housing complaint, and then we investigate them. And so what we look for then is under our advertisement, we need evidence to show that this statement was made, who was affected by it, was opportunities missed in this sale because you may have said, you know, they don't want blacks in this neighborhood or something like that. I mean, I know Louisiana realtors don't do that, but I'm just saying, in the past, we've gotten complaints like that.
Well,
So
and I
you
think
just
that-
want to make sure that it doesn't indicate a limitation and a preference, and the statement itself is not discriminatory.
Okay. Yeah, because I think in the world of what's online now,
Now it's just, wow.
the regulations apply to what used to be print. Advertising, maybe something in a newspaper, on a flyer.
Right. No, it's not like that anymore. Internet is included.
Right. Okay, good.
Yeah. Okay, so in marketing, exclusive rather than exclusive, avoid red flag words. Ensure proper use of the equal housing opportunity logo, slogan and statement. This depict diverse individuals when using human models in advertising, and also display the fair housing postal if you have it. If you want more information about fair housing advertisement, and you can go out to HUD's website, and they even have the little templates for the little housing. You can download a whole bunch of stuff. You can use even HUD's advertisement because it's free. It's just open to everybody. You can have access to all that.
Is there a list of keywords maybe that you should stay away from? I think
we're gonna get to that.
Yeah.
Yeah, we're gonna get to that. Prohibited advertising. Once again, race, color, national origin. Describe housing, not current or potential residents, neighborhood or neighborhoods in racial, ethnic terms. Do not use like white families, no Irish, no Hispanic neighborhoods. Don't use those type of terms, you know. And for neutral, facially neutral terms like master bedrooms. Okay, everybody house, you know, normally would have a master bedroom. Rare, fine, or desirable neighborhood. I wouldn't put anything else in there that can be discriminatory. Under the familiar status for children, ads may not contain limitations on the number or age of children, a state of preference for adults, couples, or singles. As describing the property, you can say like 2-bedroom, cozy, or family room, not anything that's descriptive. It's not okay to say adult living, perfect for empty nesters, ideal for retirees, because you're indicating a preference. You don't want to indicate a preference, okay? Under religion, it should not contain explicit preference on account of religion, like no Jews or Christian family home, no description. You know, you can't describe it. However, when you have a legal name of a property, that can be used. Let's just say Roselawn Catholic Home. If used, it should include the disclaimer that the home does not discriminate on the basis of race, color, religion, sex, national origin, disability, or familiar status. That just happened to be the name of the property that's being advertised. Roselawn Catholic Home, could be Roselawn Baptist Home, whatever, you know, whatever the denomination, or Jewish.
Is there a standard disclaimer?
Go to HUD's website, they're all out there.
Okay.
Just search the disclaimer, and they have them all out there. Mm-hmm. Under sex, ads for single family dwellings or separate units in a multifamily dwelling should not contain explicit preference, limitation, or discrimination based on sex. Use of the terms master bedrooms, mother-in-law apartments are acceptable terms, but don't describe the person perfect for your mother-in-law. You know, that type of thing. Okay. Okay, disability. A real estate ad should not contain exclusions, limitations, or other indications of discrimination based on disability, like no wheelchairs. Certain descriptions are okay. Great view, 4th floor walk-up, walk-in closets, services or facilities, jogging trails, or accessible features available. Those are type things. You just make a description of the property. Can describe the conduct required. If it's a condominium, like no smoking, none drinking, but don't describe the person, don't describe the individual. So in the discriminatory advertisement, we see things such as constantly, sorry, no children, no handicapped person allowed, no pets including personal assistant animals, Christian roommates only, adults only, no Catholic, no Jews, no Baptists. These are some of the basic ones that we see often. Some of the red flags are colored homes, white private home, Jews home, adult building, private single home, just for men, just for women. So as you know, advertising can be on several forms: newspaper, radio, television, billboards, brochures, flyers, posters, banners, and internet. So let's look at an advertisement example. An apartment building owner places a notice on a community bulletin board to find a tenant for a vacant apartment. The notice says Christians preferred. Is that discrimination? Yes. It is not lawful for an owner to advertise a preference based on religion. In fact, it is illegal to advertise or make a statement that indicates a preference based on race, color, national origin, religion, sex, family status, or national origin. So under senior housing, there are two categories. There are, we call them housing for older persons, and there's a category for what we call 80%. We call them 55 and older homes, housing. And do keep in mind, in that type of senior housing, 80% of those individuals have to be at least one person the age of 55, and the other 20% could be any age. Now, for senior citizens, 62 and older, that particular house is intended solely for individuals 62 and older. Under the LGBT community, if you go out to HUD's website, there's a rule called Equal Access Rule, and it's located at 24 CFR section 5.105A2, and it is the lesbian, gay, bisexual, transgender rule. If you would go out to HUD's website, it'll give you all the guidance of that. Okay.
So, Ms. Marilyn, you said that HUD's website does have a list of all the different disclaimers that can be used as part of your advertising. Do you know if there's a list of like, do not use these words?
I'm not sure, but I do know disclaimers, the type of housing, the posters that you guys may want to post. They have all that. Okay. Now, somewhere on that website, there were some examples of what to use, what to say, what not, what to prohibited. I think it was prohibited wording.
Words.
I think it's prohibited wording. I think it's out there. I remember seeing it.
I feel like I've seen some sort of like paper that gives an example of all these different words to kind of steer clear of.
Right. And I think they all stem from HUD's website. Yeah, they're out there. But HUD has actually redesigned their website under the new administration, and some things where it was easier to get to, now it's a little bit more. You have to play with it a lot. Okay. Even if you put in the search word advertisement, there's so many different components now that you can, when you get into advertisement, that it'll break you out too.
What would you say it comes through most common out of your office regarding advertisements or things that you've seen from an investigation standpoint?
The children, no children. I would say mostly the children, and not wanting pets.
Not wanting pets.
Not
so
wanting
it's
pets.
Service animals,
accommodation. Yeah. Right, and children. Those are the most big ones. So HUD has a joint statement with the U.S. Department of Justice, U.S. Department of Justice, regarding group homes. Once again, I'm going to refer you to HUD's website when it comes to group homes. And basically, it is housing that's occupied by groups of unrelated individuals with disabilities. The Fair Housing Act does not generally affect the ability of local government to regulate housing of this kind, as long as they do not discriminate against residents on the basis of the protected class. So if you go to HUD's website and look under, just do joint statement in the search engine, group homes, and it'll provide you the guidance on that. Same thing with zoning and land use. HUD has a joint statement with the U.S. Department of Justice regarding zoning and land use. And our office, because we're substantially equivalent with the Federal Fair Housing Act, we use HUD guidance on state levels as well. Now, there's another component just came out, the Violence Against Women's Act, and basically it protects individuals from domestic violence, and that is from being evicted, denying of housing, or termination of assistance on the basis of violence perpetrated by their abuser. So under the Women's Violence Against Women Act, it protects victims from domestic violence, dating violence, sexual assault, and stalking. It allows owners and management agents to request certification from a tenant that she, or it could be he, is a victim of domestic violence, dating violence, or stalking, and that the individuals, the incidents of the threat or actual abuse are bona fide in determining whether or not the protection afforded under the Women's Against Violent Acts are applicable. So more or less, if someone is being evicted because of domestic violence, you may want to readdress that if you're a property management, and they can provide you with a bona fide statement that they are a victim. And what you're looking for supportive documentation, if a person has been a victim of domestic violence, there's some type of court records, there's some type of police report, or some kind of documentation signed by an employee, in your office saying that, we witnessed this domestic violence on the property. The agent or volunteer of a victim service provider, an attorney or a medical professional from whom the victim sought assistance in addressing the abuse or the effects of the abuse. So they have to provide you with some type of supportive documentation. In 2016, HUD came out with the criminal history guidance. It's not the law, it's just only guidance. And basically, it's called the Application of Fair Housing Act Standards to the use of criminal records by housing providers and real estate related transactions. And the purpose of that guidance is to address how discriminatory effects and disparate impact methods of proof applied in fair housing cases in which the housing provider justifies or an adverse housing action, such as refusal to rent or renew a lease based on an individual criminal history. Now, the criminal history is not a protective characteristic under the Fair Housing Act. The criminal history based restriction on housing opportunities violate the act if the following occurred. If there's a discriminatory practice, there's a disparate impact, being treated differently, or there's an intentional discrimination based on the criminal history. And the reason why this was actually written is because there were some barriers. And who's affected by that action is individuals released from prison or jails has no ability to access safe, secure, and affordable housing to their successful reentry to society. Individuals who is convicted but not incarcerated, and individuals who are arrested but not convicted. Okay, so have you been arrested in public housing? Eviction for drug-related criminal activities. A person evicted from public housing or any Section 8 programs for drug-related criminal activities are ineligible for assistance for at least 3 years from the date of the eviction. And I don't know if you are a property management company, leasing agent out there that actually deals with public housing, but if someone is evicted because of a drug-related activity, they are ineligible until after 3 years from the date of the eviction. Okay, so let's get into what do I do if I'm a named party in a housing discrimination complaint. What I can suggest to you is just cooperate with the investigator during the investigative process. Whatever they require of you, provide the requested documentation, and just remain open-minded to what being asked of you. How are housing discrimination complaints received? We receive complaints in person, by telephone, by mail, by fax, and by internet. When filing a fair housing complaint, and a person has 1 year after the alleged violation to file a complaint, the Attorney General office functions as a neutral third party investigating the complaint. An aggrieved person may file a suit at his or her expense in a federal state court within 2 years from the date of the alleged violation. So they have 1 year to file a fair housing complaint if they file it with our office and HUD, but that still doesn't stop them from filing a fair housing complaint if they want to take a personal action themselves and bring a complaint to court. They have 2 years to do so. And of course, the state statute authorized the Attorney General's office to bring suit in housing situations. So in a housing discrimination complaint, we call them 903s, and that's what HUD refers to them as. But if you would visit HUD's website, or you can go to our website, HUD's website is www.hud.gov, or the Attorney General's website, www.agjefflandry.com, and you can go and fill in a complaint if, as a real estate agent, you feel that you've been discriminated or harmed somehow in violating based on the fair housing complaint. And that being said, let's just say if you had a property that you really missed a commission on because somebody was discriminating, you can file a complaint as a aggrieved party because you failed to receive that commission that you would have ordinarily would have gotten.
How would you handle it if their client, if the client they're working for is asking them or telling them or directing them to do something that is a potential violation?
I wouldn't do it because you'll be harmed. You'll be listed as a party in a discriminatory practice. Just tell them you don't discriminate. You know, you're only providing them with, once again, what they can afford, what's on your listing, your MLS listing that's available.
I'm talking about if the real estate agent is working with their client.
And their client tells you to discriminate, don't do it.
Right.
It's up to you. I mean, you can do it and a complaint will be filed against you, but don't do it. Don't participate in those practices. You know, even if it may happen once, the second time you may get caught, you know. Okay. So under the housing discrimination complaint, once again, we look at the type. First of all, we look at the type of discrimination that we will be investigating. Is the complaint overt? I mean, just blatant discrimination. On its face, the policy looks neutral, but it has an impact on a certain particular class or a different treatment. And the evidence and elements of a prima facie is what we look for in a fair housing complaint. And when it comes to real estate related transactions, first thing we want to find out is a complainant a member of a protected class? The complainant sought to purchase a house and met the minimum requirements to purchase that home. The respondent rejected the complainant's application or offered less favorable terms, or similar qualified applicants are not member of a protected class were approved by the respondent or received more favorable terms. A house was taken off of the market. So when we conduct an investigation, these are some of the things that we're going to look for. We look for statistical data. Is there a pattern or practice that's constantly being used by a real estate agent in a discriminatory way? We may ask you, or we will require you to provide us your client list, your listing agreement to sell the property, your purchase agreement, any telephone logs, email, text that you may have received regarding the sale of the property, all servicing documents relating to the sale of that property, even the act of the sale. It all depends on the nature of the investigation. Um, so the Attorney General's office, as an enforcement office for the state of Louisiana, during the investigative process, we do have what we call the mediation process. And basically, that process is offered to all the clients who wish to participate in it. It is a free service that's offered by our office. The federal statute does not offer mediation, only the state statute does. And what the parties can do is come before a panel at the Attorney General's office, which consists of two assistant attorney generals and a non-attorney, and they'll work with both parties to try and resolve the issue. But once again, that's only offered through our office. We also have what we call the conciliation process. And what conciliation is, it is a written agreement that's executed by our office. The complainant would tell us what is it that they're seeking as a result of filing the complaint. And you as a respondent or the respondent would have the option to accept or reject it or make a counteroffer. And conciliation runs through the course of the investigation until a final determination has been made. If the evidence showed that discrimination occurred or there's discriminatory practices, well, then our office will file suit in the state district court on behalf of the complainant or you as the real estate agent if you are an aggrieved party. So, wrapping it up, you cannot discriminate against someone by retaliating against them if they file a fair housing complaint. You can coerce them, intimidate them, or threaten them in any way once a complaint has been filed. So in celebration of the 50th year of the Fair Housing Act, you can always go to HUD's website, and they do have some information out there regarding the 50-year celebration. I think there's a lot of photos, you know, some previous event that has taken place, or you can actually go out to HUD's website. You can reach us at toll-free 1-800-273-5718, or you can call us locally here in Baton Rouge or across the state, 225-326-6400, or you can visit the website at www.agjefflandry.com or HUD's website at www.hud.gov. So this concludes my presentation. I hope it was very helpful to you and enlighten you on the compliance part of the Fair Housing Act as to what we look for and what we do at the Attorney General's office. I do know, I think in September, we're going to have another workshop, and that's going to be held by HUD, and they're going to get more in depth as to how to be more proactive as realtors. And basically what we were covering here was mostly the compliance component.
We're really appreciative of the Attorney General's office and what you guys have done. We helped coordinate and work together to follow a resolution in the state legislature last week during Realtor Day.
Yeah.
It was great to have Gary Sweeney and representatives from both HUD and the Attorney General's office to celebrate fair housing. At this time, those of you who participated today, if you have questions that you'd like to ask, I know sometimes there's scenarios that happen in the field that realtors want to know, can we do this, or what falls within the guidelines? We can take some questions or anything like that and answer those. If it's okay, several people have asked to give copies of these PowerPoints. Is it okay if we send it to them?
Oh, I don't see why not. It's a public record.
Right. It's good information. And we thank y'all for joining us, using your morning to learn a little bit more about fair housing, the protected classes.
And do feel free, if you have a question, call us. We'd rather you to call us. If you feel like you're in a really sticky situation, call us, and we'll be able to walk you through it, you know, to help you to avert getting one of these complaints filed against you.
Wanda, I show that you have your hand up again. Did you have another question that you want to ask? There's a question box on the corner, on the right corner of your screen. Okay, looks like you're getting off easy. No
Oh,
questions
good.
are coming
Awesome.
in.
Well, you guys have a wonderful day. You've been such a great audience, and we look forward to doing this again soon.
Thank you, everyone. Have a great Monday. Have a great week. Thank you for joining us. We will provide this recording. We'll send it out probably in our weekly newsletter this week so that we can have more people informed. Thank you, Monica. Monica said this is great information. Thank you, everybody, for tuning in. Have a great week.